Good morning. In today's lecture series, we are going to consider the amendments to Maharashtra Public Trust Act. You are aware that from 2017 onwards, there are various amendments which are introduced to Maharashtra Public Trust Act. Many of lawyers have also not studied these amendments properly, and the interpretation of these amendments are not considered. As a result of the same, though the amendments are made effective, they have not come into implementation in a way in which they were required to be. Therefore, for us, it is necessary to know the amendments and to know how to implement them effectively. What is the legislative intent behind these amendments? Accordingly, we can use it in the regular practice. Coming to the first amendment in this regard, there is an amendment to section 22, whereby the concept of provisional acceptance has been introduced. This is a very important and welcoming amendment introduced by the legislature in the year 2017. By the Act of 45/2017, this amendment has been introduced by the Maharashtra legislature. You are aware that previously, under section 22, if change report is going to take time, then there was no effective machinery or there was no effective mechanism whereby that particular body of which the change report is filed but the change report is pending for adjudication can be declared to be a proper or a legal effective body. And as a result of that, the trustees used to be suffering various problems, particularly with respect to operation of the bank accounts or making applications, representations to the government for obtaining the land on leasehold basis or for educational activities also. And therefore, this was a issue which was arising, which was there in the minds of trustees for a long time. Similarly, when there were rival change reports filed and there are rival change reports pending, then in that case, which change report will be on the better position? There are no particular machinery or mechanism was provided for the purpose of that. And therefore, this need had arisen that for the purpose of having some mechanism or some enforcing machinery or something which will give the trustees whose change report has been filed a recognition that yes, they are trustees. There was a concept of de facto trustee and de jure trustee and under Chembur Education Society's ruling of 2011, where it was decided that a change report once is filed, it was ruled that, observed rather, that whenever the change report is filed, the change is recognized as or the trustees in that particular change report are recognized to be the de facto trustees. And once the change report is decided, they become a de jure trustees. But again, there was a dispute with respect to this position also. And there were certain previous rulings where it was said that in case of an administrative difficulty arising when there are two rival change reports, then in that case under 41A, the charity commissioner may decide which is on the proper change report on the better footing. But again, it was the administrative proceeding under section 41A, and therefore the legality to that cannot be said to be given, or a legal ruling verdict on the basis of that was not coming. And therefore, when this concept of provisional acceptance came and when this was introduced, it became a welcoming change for all the trusts which are under Maharashtra Public Trust Act. Now, section 22, two provisos are introduced to section 22(2). Under section 22, we are aware that a change report is filed, and under section 22, it is said that in order to decide the legality and validity of the said change report, the charity commissioner may carry out the inquiry. And that inquiry is subsequently given that under section 22(3), the procedure for inquiry has been given. Accordingly, the inquiry is undertaken. But under section 22, two provisos have been added, whereby the concept of provisional acceptance has been introduced now. The proviso to section 22 says that this inquiry will be carried out, but it says that once the change report is filed, within first 15 days from the filing of the change report, the charity commissioner may consider the application for provisional acceptance and may grant provisional acceptance to that particular change report, which means that believing that the change report is correct, the charity commissioner will grant the provisional acceptance and then issue notice inviting the objections, if any, that if the change report is there is any objection to that particular change report. And if there is no objection received within 30 days, then in that case, that particular change report will be considered, inquired, and the necessary orders will be passed. effect of this particular amendment is that change reports, even the uncontested change reports which are pending for years together, that will be decided. Those change reports can be decided within the span of 30 days or maximum within the span of 60 days, because if the charity commissioner takes time for the purpose of passing orders even on the uncontested change report after the provisional acceptance notice has been given, and if there is no objection issued, then that change report can be safely inferred to be a correct change report. No doubt the legality of that change report will have to be considered judiciously, and thereafter only the order will be passed by the charity commissioner. But the charity commissioner thereafter can directly take the matter for the purpose of inquiry and passing of the orders. So this was the legislative intent, and therefore the statement of object of this particular proviso has mentioned that this proviso will be applicable to the uncontested change reports. By taking this particular line into consideration, the Office of Charity Commission in many districts, it is seen that they are saying that the concept of provisional acceptance we are going to use only for the uncontested change reports. Then issue comes is that what about the rival change reports? Many times what happens is that with respect to a tenure trustees, for example, a tenure is of 5 years, say from 20 to 25, and in the year 2025, when the elections are due, at that time, two bodies are there, two parallel bodies claim that we are the legal body and we have conducted the elections and our election is a genuine one, legal one. And accordingly, two change reports are filed for the subsequent change of the tenure for 25 to 30. Then what to do? If these two rival change reports are there, the fate of these rival change reports as on today is that it goes on for pending years together, sometimes more than 5 years also, and as a result, by the time the next sessions come, till that time also this is not decided, and this leads or creates a chaos in the administration of the trust. But as I said earlier, the legislature had intended in the statement of object that this particular provision will be applicable for provisional acceptance only to the uncontested change reports. Then the Honorable High Court of Bombay has come in play, and there are various rulings which have come after 2017, wherein it has been held by the by the Honorable High Court in various matters in decided cases that the concept of provisional acceptance can be made applicable even to the rival change reports. Even if there are disputes among the trustees, still, and there are two rival change reports, two parallel change reports, still this particular concept can be made applicable. There are various decided cases from which some principles have come forward. I'll just quote that to you. I'll not name the cases because the cases you can go to the annuals AR portals and find out the cases regarding that. The first thing is that the proviso says that within 15 days from the date of filing of the change report, the provisional acceptance application should come. But the Honorable High Court has observed in a case, so I'll just name the Kirwai Education Society versus State of Maharashtra, where Justice Jamdar has observed that though the period of 15 days has been given, the provisional acceptance application can be filed even at a later stage also. So even if at a subsequent stage also, if the parties filed that the provisional acceptance need to be obtained because the change report is going to take time, substantial time, then they can file the application for provisional acceptance and that can be considered. In another ruling, it came that in case of a rival change reports, the provisional acceptance application can be filed. And it has been observed by Justice Marne in a case that even if there are rival change reports, the application for provisional acceptance can be filed. And at that time, if another change report is pending and application for provisional acceptance is filed in one change report and not in the another change report, then the Charity Commission should take a cautious note of that and will give the notice to the other party also, the other parties in the other change report, rival change report, and consider both the change reports together, and we'll find out which is the proper change report, and accordingly the provisional, proper means legal and valid change report, and accordingly the provisional acceptance can be given. So accordingly the provisional acceptance application can be filed even in the rival change reports also. Now thereafter in the latest judgment, recent judgment, it has also come that if the provisional acceptance application is filed in the change report and there are rival change reports, then what is required is that the principles of natural justice have to be complied with. The opportunity of hearing has to be given. If there is an objector or if the charity commissioner finds objection to this provisional acceptance change report, because for the same tenure another change report is filed, or somebody raises objection, then to that particular change report, then hearing can be given, and on the basis of the hearing, the charity commissioner can decide whether to grant or not the provisional acceptance. So that this is also a very important thing. Accordingly, now even if there are rival change reports, parallel change reports, still the provisional acceptance can be granted by the charity commissioner. For that purpose, the party, the reporting trustee who has filed the change report, if he is desirous of getting the provisional acceptance order, then in that case, that particular RT, reporting trustee, has to make an application to the charity commissioner, and the charity commissioner will consider whether any rival change report is there. Accordingly, it will give the notice of hearing to the other party, and after hearing the party, the provisional acceptance can be given. In case of the uncontested change report also, it is necessary that you must file the application along with the change report only for the purpose of provisional acceptance, so that it is an uncontested change report, then immediately the charity commissioner can pass the order of granting of the provisional acceptance, and then later on he will issue notice. If there are objections, the objections will be considered. Now try to understand the importance of and relevance of this. By virtue of introduction of this provisional acceptance, in my opinion, the concept of de facto and de jure trustee has gone. Now the government authorities will not entertain your applications or will not recognize your change reports on the basis of the concept of de facto trustee, that yes, we are the de facto trustees and therefore our change report should be considered. Even the banking authorities may not consider the change report purely because it has been filed. They will ask, you must get the provisional acceptance. Because since the concept of provisional acceptance has now come, the concept of de facto and de jure trustees, which are there under Chembur-Tombey Education Society, has now lost its effect. And therefore, now it is a need of the hour for every trust to take into consideration this particular fact. And accordingly, whenever the change report is filed, the application for provisional acceptance should be made. At this juncture, it is necessary to consider in what matters you can prefer an application for provisional acceptance. There are two contingencies where names or addresses of the trustees or managers are changed, or if as per the mode of succession, the trusteeship and managership is changed, then in that case you can ask for provisional acceptance. So provisional acceptance cannot be asked for with respect to the recording of the property of the trust, or you cannot ask the provisional acceptance with respect to the amendment to the constitution of your trust, instrument of your trust. But it can be definitely asked with respect to the mode of succession of the trusteeship or managership, or with respect to the change of names and addresses of the trustees. Since it has been mentioned that trusteeship and managership, it includes a change report with respect to Societies Registration Act also. So any trust which is also registered to be a trust under Societies Registration Act, F section trust, those trusts also, for those trusts also, getting this particular provisional acceptance certification, if the change report is pending, is now mandatory. Therefore, it has to be taken into consideration, and the necessary steps for that purpose will be required to be taken by the trustees as early as possible. Thank you.